Live. Assalamu alaikum, everyone. Thank you for joining us today at another great panel discussion at the National Incubation Center. I'm Fasieh Mehta, the program manager at the NIC. So thank you all who have joined us via this Zoom webinar in attendance or also on our Facebook page. Today, I have an old friend with me as a guest that I have a privilege to talk to today in light of the recent changes that happened in the Companies Act by the Securities and Exchange Commission of Pakistan. And this friend, as you may all know because you joined the talk, is Barrister Ahmed Uzair. And knows no introduction those people who work in the startup space, by the way, because he has been, mashallah, working with startups and has been quite an advocate of the technology law. He also advises various incubators, accelerators, VCs, and many startups as well. So Barrister Uzair actually completed his LLB from Cardiff in the UK and then was called to the bar by Lincoln's Inn at the age of 23. Barrister Uzair also routinely writes and has published papers with Pakistan Law Digest and the Council Magazine, Karachi, and also the Human Rights Journal. He's the co-author of a book titled Alternative Dispute Resolution Review, published by the Law Business Research in London. And he's also the co-author of Pakistan's first corporate law magazine called The Council. He's the founding member of Continuing Legal Education Initiative of Pakistan, which aims to raise the overall standard of the bar. Welcome, sir.
It's my pleasure to be here. Thank you, Fasieh.
So, Uzair, this will be a mixed English and Urdu conversation. We do have audience who has their background as founders, probably startups, or working within teams of different startups, and would be asking lots of questions. And guys who want to ask questions who have joined us on Zoom, you have the Q&A section. Please do ask and we will take the questions at the end, we will answer them. And those who are joining us on Facebook Live, post it in the comment section. NIC team is already looking at the comments. They will be pasting it here in the form of a question and we'll take it live, inshallah. So Uzair, tell us about yourself, other than the very brief intro that I gave. Who is Uzair and how did you end up with technology and startups?
So this is an interesting question. I've been involved in some way or the other with the technology sector from 2004. This was around the period when I was finishing my A-levels, and I used to work at a call center at night. And you can imagine the energy that's there, and the young guys and girls who are working in those call centers are generally the techie type, and I always found myself very comfortable around that. And so it's been something that I have very much enjoyed. I actually wanted to be a computer engineer, but as luck would hold, I ended up becoming a lawyer. But I'm very lucky because now I'm able to work with the same engineer friends that I had at that time. So for the last 14, 15 years, some of those are entrepreneurs in themselves, and I'm very happy to work with them. So it's been a coincidence. I don't have anybody in the legal profession in terms of my family. So this was just a coincidence that I happened to become a lawyer and a barrister.
Right. Sometimes coincidences happen for a very right reason. So, Uzair, before we jump into the Companies Act amendments that were promulgated 30th April and turned into a law, and I believe this was after a series of consultations in which we also met earlier. SECP did many road shows. I know Shazab, Abdul Rahim, and their team did a great job. And there are many questions on Sandbox and force majeure, how that's going to be playing in COVID. But before we get to all that, the juicy part, let's go to some very basics. So the State Bank of Pakistan in its prudential regulations defines what is a small and a medium enterprise or a large company, depending on the basis of the employees and also on the sales or the turnover. Similarly, there are somewhat little different but similar definitions by the FBR, but SECP also had the same. Nowhere there is a definition where startup can be classified. Has that been fixed? And if so, what is the definition of a startup now?
That's a very good question. So it was one of those questions that probably attracted one of the most heated conversations when we were doing the roadshow with the SECP, and we looked at what a lot of other countries have done. You have correctly pointed out that State Bank has a definition of a small and medium company, but they don't use the word startup per se. What the FBR has done in the income tax ordinance is to define startup as very narrow, tech focused technology company essentially, which working with a lot of startups I felt was a little too narrow and did not reflect the wider tech, entrepreneur and ecosystem that we have, startup ecosystem that we had. And so we wanted to give it as broad an explanation or definition as possible without making it unreasonable. So essentially we have three criteria. Number one, you can be a startup if you are younger than 10 years in terms of when you were incorporated as a company. That's number one. Number two, if you have at any point in time in the last 10 years had a revenue, a turnover of more than 500 million, then you go outside of that definition. And thirdly, perhaps more interestingly, it is if you are an innovative company, you are bringing about a change in the industry that you're operating in, and it is a rapidly scalable business. If that is the case, then you will be classified as a startup. Now, if you try to be a little nitpicky, I would say that this is also susceptible to multiple interpretations, but looking at the language, I feel that it is broadly as wide encapsulating as possible in terms of what you can classify any startup that you deal with or has otherwise looking to raise capital, for example.
So thank you. So you said that there was a lot of back and forth and there was a heated discussion on the definition of startup. What were those reservations and how much, to what extent those reservations have been addressed in this definition? And secondly, is this definition harmonious across SECP, FBR, and State Bank?
So it has definitely been reflected. I think the definition that we had originally internally drafted, I mean the SCCP had internally drafted, was perhaps a little restrictive. The number of years, for example, we had originally proposed were 5 in terms of age of the company. Now it is 10. So this came up in conversations. And so definitely feedback was incorporated, and the language that we finally have in the Companies Act now is reflective of that feedback. Now, whether we have a harmonious definition or not, the short answer is no, because obviously FBR hasn't had the chance to look at its definition, which obviously was introduced a couple of years back to give special tax benefits, and this is something that is probably going to be rectified in the near future. So currently the tax law is a little narrow in terms of the benefits that are given to startups, whereas what the company law now proposes as a definition is probably much more broader.
Thank you. So while many other areas were addressed in this amendment, actually, one more thing first, I go there. Many people are calling it the Startup Act or law. I believe it deserves a clarification from a barrister as well. I've been talking about it. It's the same Companies Ordinance 1984, which has been amended time and again, and now it's the 2020 Companies Act. Can you please touch upon that as well?
My pleasure, my pleasure. So I don't need to go into the history of how Companies Ordinance 1984 came about, but we had Companies Ordinance 1984. We've all grown up utilizing that. In 2017, a new law was passed. It is now called Companies Act 2017. by and large, it is a new law. It recognizes technology. It recognizes the incorporation of technology in the way the companies are formed. A lot of documentations are filed. A lot of meetings are conducted. A lot of board meetings are conducted digitally. So the law has been substantially modified, and I would classify it as a 21st century law. And it obviously isn't perfect. And what the 2002 ordinance has done is it has amended some sections of the Companies Act 2017. So we can forget about the Companies Ordinance 1984 that has been repealed, except some minor sections. But other than that, we have the new law, which is Companies Act 2017, and this ordinance essentially makes changes to some sections.
Fair enough, but there is no separate startup act that has been passed. That's what I wanted to clarify.
No.
Yeah. So yeah, a lot of friends who have joined here and those who probably are watching us on Facebook, many of them asked me about startup law. So just wanted to clarify that the law is not called a startup law, it comes under the Companies Act.
Yes.
Let's start from a very big pain point that we've seen in the industry for a while. And one of the great advantages in West or other countries where startups have really flourished is because of employee stock option plans, or ESOPs for short. So stock options have been really, really lucrative. When you reach the scale of going for an exit or a buyout or an IPO, they come in handy, and you don't have to burn a lot of cash at the initial days. You stay lean, but also you keep your staff very motivated. What has been done regarding stock options? How can our startups access it? What is the process? So can you please shed some light on that?
Certainly. So when we went to the SECP and we identified the issues that we had with the company's law, employee stock options was certainly one of the issues that were highlighted. They were very kind enough and receptive, and they understood what ESOPs were. So interesting, and let me link it to the last answer I gave you. Now, the Companies Ordinance 1984 did not talk about employee stock options, whereas the Companies Act 2017 did. And hence, everybody knew what it was. The only problem was that the law had limited it to public limited companies. Now, employee stock options are very common in the West, and they do come in the form of stock options given to employees by listed companies. So, and it is now common for even private companies to issue them. And so the trickle down from what we had to what we now have achieved wasn't a lot. Essentially, the block that existed that said that this mechanism is only available to public companies has been removed, and now even private companies can avail it. Now, what it means in terms of the mechanics, I don't have a ready answer for you because, as I pointed out, the mechanics will be introduced in the form of regulations. And currently, the SECP hasn't promulgated the regulations. We're probably going to develop those regulations so that people can start issuing employee stock options. But if we have to go anyway by the manner in which it is done for public companies, you pass a board resolution that a certain percentage of the outstanding share capital is going to be issued in the form of employee stock options, and you submit it to the SECP, and it's just a regular filing that you do, like a lot of filings. So provided the mechanics are similar, we will have the SECP is going to give you the green signal, and you will be able to issue those employee stock options to your employees. Now, as you can, we can just briefly discuss what is the benefit of ESOPs. Now, for a startup company, if you want to attract quality human resource, sometimes, and in fact, most of the times, you do not have the capacity to pay them their market salaries, right? And so you tell them that this is a high growth startup, work with us for 3 years or 2 years. And once we either get some sort of a funding or an exit or an IPO, you're going to reap a lot of benefit in investing yourself with us, and you reward them in the form of employee stock options. And so those options essentially are a hook for the employees to participate and work towards the growth of the company. And so it gives the employee a certain sense of ownership as well.
Brilliant. We're getting lots of questions. We'll take them at the end. It started. So keep them coming, guys. It's very nice. I'm going through the questions that you're putting out there. So you mentioned about the stock options being there. Has there been any issue in terms of the stock options being utilized by startups vis-a-vis companies who are fairly well structured or fairly well funded? So what do you think has been a challenge in asking more and more startups, especially lots of us who run these incubators and the community of all the national incubation centers, for instance, they would like to know as well. Yeah. How can very small stage startups can get more benefit out of it? Because mostly, and it might be a perception that it is for more structured companies with large fundings and all that, and the process or the documentation is fairly large. So do you think it is easier for small startups as well to apply?
Certainly. So it is just like setting up a company, right? So once you are setting up the company, you tell the regulator how or what are the number of shareholders. So for example, if you say that you and I are setting up a startup, we register that company. Now, let's say that company has 100 shares and you decide that you and I both have 50 shares each. Now we decide to employ the services of let's say Abid, and we want Abid to be part of the company, and we say that you will give you 10 shares provided that you work with us for 2 years. Now what are we doing? We are giving that employee a stock option. We are telling that employee that in 2 years time you will have 10 shares which currently are valued X, but will probably be valued much more in 2 years time. And this was still happening before this change was introduced. But it was unofficial. What was typically happening is either yourself or I would be issued those shares in the company, and we would then after 2 years transfer them to Abid. But now what we will be able to do is tell exactly what it is. This is beneficial for not just you and I, for clarity's sake, that what share is yours, what is mine, and what Abid's will be in 2 years time will be in 2 years time. But what it also helps is a potential investor understanding exactly what the structure of the company is. And so there is certainly no complexity. And I've given you a very simple example for between 3 people setting up an employee stock option.
Thank you so much. So this takes me to the next part as well. So often we've seen in cash-strapped startups, owners and employees, they typically accept salaries which are below their market values, right?
Yeah.
And in return for a stake in the company, often called as sweat equity. So how is sweat equity now addressed? Was it not part of it earlier? And is the process of calculating it and realizing it addressed in the new law? Can you please also share more details about the sweat equity area?
Certainly. So there is certainly some overlap between what sweat equity we are talking about, sweat equity and employee stock options. Essentially, it can be in a similar scenario. But the way I look at it is that sweat equity is generally for consultants. So you, for example, we both start thinking about let's say an artificial intelligence based technology solution. Now you and I both are not scientists, and we are not professors of artificial intelligence. We say that we employ the services of a university professor, and we want to give him or her some stake in the business for the effort that they are going to put in. They're not employees. They cannot be employees. So they're not strictly falling under the employee stock option plan. But what they are is professionals, specialists who you want to be part of your company. You don't have the money to pay the professor, but you want to offer them an opportunity to be a shareholder in the business. And that shares that they are being issued is in the form of sweat equity. Now, in the strictest of senses, uh, sweat equity was allowed. However, there was a fundamental issue, and that issue was that you were required to have the value of the contribution valued by someone appointed by the SECP. So, for example, if you and I are coming together, let's take this example forward, and Shahryar is the expert that we want to employ, and we feel, you and I, that his contribution is worth, let's say, 1 million rupees. Now that 1 million rupees translates to, let's say, 100 shares in the company, right? Now we want to give this Shahryar 100 shares. You and I both agree we are the owners of the business, right? And so we want to give Shahryar the 100 shares, and he is comfortable taking those 100 shares for the services that he's giving us. However, the SECP originally required somebody, a third person, to come in and value Shahryar's contribution and confirm that Shahryar's contribution is indeed worth 1 million rupees, which was obviously difficult for startups, right? So it is difficult to quantify somebody's service. There are tax implications associated with it. And so it was essentially impossible to undertake. Now, what the law has done is essentially made it easier for you as a startup to issue sweat equity, and provided, now again, for this, the SECP is likely going to amend the issue of share capital regulations 2018 in light of what has been changed in the law. And once that is done, I believe that you will not be required to go to a valuator, essentially a third person, to tell us, you and me, whether we should give those 100 shares to Shahryar or not. Because this is how I explained it to everybody, right? So if you and I are 100% owners of the business, and you and I both agree that Shahryar should be given a certain percentage of the business, we don't need a third person to tell us whether what we are doing is right or wrong.
So this is, I believe, a great relief that you do not need third persons or by any regulatory or any other regulatory watchdog to come in and tell you. And this has been a pain. But there's also something else which is very much related to sweat equity and issuing of shares to the employees, which is share buyback, right? When you have to buy them back for whatever reason that it may be. Or also called as share repurchase. Can you also shed some light as how it affects startups, what stages they can be eligible to go for buyback, what is the requirement they have to fulfill, and how does the law, in which section of the law perhaps, if you'd like to share, governs this part, and what is the new thing that has been done to cover the share buyback?
Certainly. So let me first tell you, like ESOPs, this was actually quite an easy sell because the law as it existed originally companies, they do buy their shares back, and this is essentially a tool that a lot of large scale companies use to prop up the value of their shares. Think of it this way: if you have 100 shares and each share is worth 1 rupee, and the company buys back the 50 shares, the price of the share essentially doubles. Why? Because the number of shares are now 50 instead of 100, but the value of the business is still the same. So this was a common tool for public companies, but was not available for private companies. And the reason or situation where this is useful for startups is essentially, and I've often given this as an example, that a lot of startups fail because of co-founder dispute. And one of the reasons of co-founder dispute is a founder wants an exit and wants to leave, but there is no option to exit, right? So what this tool now allows the company to buy the shares from the exiting co-founder. So the terms and conditions of that exit can be negotiated by the company. Typically, founders don't have the funds to pay other co-founders, right? But the company might, especially if it has certain amount of revenue that is coming in, but it is not in a position to pay any dividends. But what it can do is utilize those funds to buy back stock, and that has now been allowed. So for me, it works for especially those startups where, let's say, there's a third startup. There are three founders, and one of the three founders wants to exit and wants to leave the company, but he doesn't want to transfer his or her shares immediately to the other founders without there being a formal arrangement for buyback. This law now certainly allows that, and this is covered under, I believe, under Section 88. Now you're putting me on the spot. I don't remember the sections, but I think in some Q&A
I just wanted to check, are you loaded on your caffeine after iftar or not?
Yeah, I'll look it up.
No worries. Just we can always share that with our audience later on, and they can also go online and search it as well on SECP's website. So thank you for sharing that. I have another question. So with all this that is happening, whether it is the stock options for the employees, ESOPs, or the sweat equity, or the share buyback, how does this open door for international investors? What all these amendments, and we are going to talk about a few more as well, how does this help startups in getting investments, and how does it secure the interest for investors?
So before
whether international or otherwise VCs.
So before I answer this, I do want to point out, and I do want to give a shout out to the SCCP, right? So as a regulator, it has taken a very proactive approach towards understanding what are the problems of the startups and trying to find within the confines of the law whatever solutions are available. When the law became a problem, they themselves went to the government and said that we want to change the Companies Act so that it benefits startups. So we should give the SECP the credit that it deserves. What these changes essentially mean for me is that they bring them in line with what is standard around the world. Now, this is standard anywhere that you look at as far as startups is concerned. Employee stock options is such a common practice for early stage startups that it was quite harmful that this was not available, and hopefully a lot of startups will be able to utilize this and reward their key employees, and so that they can grow rapidly. Same goes with the sweat equity. It was such a pain to structure a transaction where you had a consultant and you want to compensate the consultant, the university professor, and the solution used to be that you used to route funds into the company indirectly and then pay that consultant back, and the law required a bank statement confirming that consultant had actually paid the funds, and so it was a nightmare, and it did not reflect the reality. And the reality is that the company wants to issue shares to a certain person for their sweat, and it shouldn't be too complicated. And thankfully now it is definitely less complicated than what it was. I don't think that, and I think we both can agree on this, that we are not in a perfect world. And as far as the regulations go, they are not in their perfect place. There are two other very important stakeholders in this. One is the FPR and the other is State Bank. I do feel that both of the other two regulators have to step up, and they have to do a lot more than what we have right now. And perhaps with all of that coming together, we will have the truly rapidly growing startup ecosystem that we see right now.
Certainly, since you pointed out the great role that SECP played, I would also like to give a shout out to the commissioner and his team, Shazab, Abdurrahim, everyone. You were one of the authors, and I've seen you in the road shows as well. I believe it was very nice that SECP this time went out to consult with corporates, with every stakeholder, with development organizations, with government organizations, with startups, with investors, with NBFCs, with VCs. And there was a lot of consultation back and forth. And I'm glad, as you mentioned in the start of the conversation, that just the definition of the startup was amended because of the feedback that was taken from the roadshows. Yeah, so this shows a good progress. And I hope that other organizations, other regulatory bodies in the country also follow suit. So yeah, it's glad, it's good that, that at least those who want to invest or who want to work with Pakistan's companies or startups, they know that some of these regulations are now at par with international standards. Speaking of which, we also heard about SECP launching recently a sandbox. So first, if you'd like to just explain to the audience who's not aware of what is the sandbox, what does this allow them, and what was the rationale behind this, that and what objectives have been achieved so far? Because I recently saw that they're inducting, I believe, for the next cohort, or
yes.
There was some message floating around from our friends from SECP recently. So yeah, if you could please share some details with us on the sandbox.
Certainly. So Sandbox is an interesting strategy, right? So I'll briefly tell you what it is. Sandbox is an idea where if you have an innovative solution to a problem, a real world problem, however, you are faced with certain regulatory challenges that you feel that you will not be able to pass, you can join a sandbox where the regulator sits with you as your partner, explains the regulations, understands the problems that you're facing, and helps you navigate them for a certain period of time. Now, you've heard about the applications for second cohort. I believe the results for the first cohort are going to be announced. Maybe they're expected in the coming week. So that's quite interesting. And I'll give you a couple of examples which are likely to take benefit from the regulatory sandbox. So consider the example of an equity crowdfunding. So equity crowdfunding, in the strictest of senses, isn't permitted under law. However, it is a very powerful tool to attract capital from the market, and without you're not doing any stock market listing, but at the same time, you as a founder and as a startup, if you have a crazy good idea, you can attract a lot of investment, and billions of dollars are being poured into innovative solutions around the world against in return for equity in the form of equity crowdfunding. And so most likely what is going to happen is that if as the startups that are operating in the equity crowdfunding space will be able to work under the regulatory sandbox, which essentially provides a protection for the startup. They can spend 6 months to a year and during this time they can develop their solution, look at exactly the regulations that are problematic, and it also gives the regulator, in this case the SECP, a very good window into understanding exactly what the solution is and how this particular startup is solving that problem. And based on that, it can design and further improve its regulatory regime. And so it is sort of like a marriage between the regulatee and the regulator coming together, identifying an area where there are regulatory hurdles, solving them, and making it easier for others to do business in the same in the same domain.
I believe there has been a focus on many regulatory reforms within the fintech industry or the non-banking financial companies, and I do see more focus there, which is good, and we need to do a lot of work in that areas. I also encourage all the startups and innovators and entrepreneurs who joined us or watching us to join SECP Sandbox. If you want to contribute, if you know of a problem that you, or a hurdle that you're facing, and let's find more innovative ways. This is a great opportunity, guys, because when organizations like SECP are so open and welcoming, let's make the most of it. So Uzair, as we're all going through this very unprecedented times, or the new normal that everyone is calling it, COVID has also impacted many existing contracts.
Yeah.
Most of our startups, so we did a survey of around 40 startups earlier at the NIC, and we realized that around 24% had to shut their business down or halt their operations because of COVID, or the result of COVID, the lockdown earlier. Now that is easing up. Some of them actually pivoted. Most of them went on to these grocery deliveries and similar other businesses, while some who had raised a round, they were almost shut down, and many had to let go of a lot of employees.
Yeah.
This brings one major clause into action, force majeure.
Yeah.
To what extent the force majeure can be enacted in terms of how contracts are changing, and not just because of the fact the startups in Pakistan are doing it with their employees because of the certain issues, but it also they're facing this same thing vis-a-vis commitments with their international buyers or customers outside Pakistan. So how does that come into play? Can you please shed some light? Because this was a question that I was asked by many friends, and I thought, okay, I'll put it through today to you.
Good. So let me preface everything by saying that I think a lot of people are throwing the term force majeure around quite casually, but it has a very specific meaning. And a lot of audience, I think, would be surprised to know that force majeure is not actually recognized by Pakistani law. Force majeure is actually a French term. It comes from civil law. What we have in common law, the legal regime that we follow, is called frustration. Now, frustration essentially means that if the subject matter of a contract ceases to exist, then it will be unreasonable to ask a party to continue to perform it. So I'll give you an example, that if you were supposed to, let's say, trade with or send a particular shipment to another country, and a war is declared between the two countries, and it becomes illegal for you as a company to ship those products to that second country, then essentially what has happened is a frustration event has happened. And now it is practically impossible for you to perform your part of the contractual obligations, even if you wanted to. Now, force majeure is slightly different. Force majeure only comes into play. Number one, it only comes into play when you have it incorporated within your contract. Number one. Number two, it has to represent the exact event that you are talking about. Now, for example, if your force majeure event says that in case of earthquake or fire or building being damaged, me as the tenant will not be required to pay you, the landlord, then you can use the force majeure clause. But if you have a standard force majeure clause which does not mention any of those events, and those events do not happen, then you will not be able to claim it. So as I said, number one, it has to be included in your contract. So it is essentially what you and I agree to write, number one. Number two, what exactly is the language that has been used? So if your language does not incorporate the exact force majeure event that you are claiming, then you will not be able to take benefit from it. For example, let's say that I am a supplier and you are my customer, and I'm supposed to supply, let's say, 100 cartons of a product X to you, and I deliver those 100 cartons of product X to you. And you say that, sorry, my business has been shut down because of COVID-19, and now I will not be able to pay you. Now that force majeure clause, even if we have that in the contract, cannot come to your benefit, because I have performed all of my part of the bargain, and you are essentially saying that you do not have the money to pay me. Now, the fact that you do not have the money is not a defense that is available under force majeure. You can't use that. Now, let me reverse this example, the same example. If I'm supposed to give you the 100 cartons, but the government asks me to shut down my factory, right? Because of the COVID-19. And I have shut down my factory, and I was supposed to deliver those cartons, let's say on the 10th of May, today. But because of the closure, I'm not able to operate my factory. And in our agreement that we have drafted, specifically it is written that a party will be excused from performance if it is prevented by a government order from performing its obligations. Now, if we have that language within the contract, then I can take benefit from that, and I can say that, sorry, I've been delayed in performance, and this is the reason, this is a justification, and now you can't claim that I've breached the contract.
Thank you. This gives a lot of clarity, but even though if, for instance, force majeure was mentioned in the contract and people are saying that because of the demand that has gone down, because of the government enforcing a lockdown, we cannot fulfill the orders. Hence, I do not need a further supply from you, and you cannot hold me liable. Does not, what you're saying, does not apply force majeure.
No, if you have, no, that's a very good example you've given me. So if you and I have this contract that says that there is a force majeure clause, right? And and we both agree that that you as the customer and me as the supplier, you as the customer say that I don't want any further orders because of this reduced demand, and I would like to terminate the contract because of force majeure. Then I think you will be able to do that. All I'm saying is that you need to see if your contract, the language of the force majeure clause allows you to do that. If it does, then it should be fine.
Okay. So we're getting lots of questions as well, and I would proceed to Q&A just in a bit, guys. So hang in there. I have a few more questions to ask of my own before I go there. So there were, other than these major things that we discussed regarding the startup being recognized for equity, there were certain other changes to the law, I believe, as well. But before we go there to some standard changes, which I know regarding company C and certain other board regulations, etc. During the roadshows, we also discussed the crowd equity funding. Has that been addressed in this law, or is it something still in the works?
No, it has not. It has not. And it is frankly, I don't think required to be addressed in this company's law. So there is nothing as such in the company's law that prevents a party from undertaking equity crowdfunding. What is required is incorporating particular regulations to allow equity crowdfunding to take place. There is perhaps some change required in the Securities Act, which is a different law. But the Companies Act itself is quite open to interpretation, and we can certainly say that the law does not prevent equity crowdfunding. However, the regulator, in this case the SECP, feels that there should be some regulations around equity crowdfunding, and they are likely to be introduced after the Sandbox. So once a few equity crowdfunding platforms are operating under the Sandbox regime and they understand exactly how they are operating, what their business models are, then we will be in a position to have regulations for the equity crowdfunding. So as you know, that we did draft initially a basic outline of what those regulations would be, but within the SECP and the regulator, I felt that they felt that they needed more time, and perhaps they could send the startups, the equity crowdfunding platforms, to the Sandbox regulations first, allow them to operate there for a few months, and then introduce equity crowdfunding regulations formally.
All right, thank you. What other standard changes have been made in this act regarding removal of company seal, etc.? And does these changes also apply in terms of any relaxation of filing of documents?
Certainly, yes. So I'll just talk about 2-3 which I feel that will probably be relevant to the startups. I do want to mention that these are not all the changes that have been made. And this again goes back towards people suggesting that this is a startup law. The changes to the Companies Act actually introduce a lot of changes. And what we are discussing are only the ones that I feel are relevant to startups. So the first and perhaps the most obvious, I believe the change is to remove the requirement of company seal. A lot of companies have actually have stopped even making company seals. It used to be a big, I don't know if you've seen it. It used to be a big stamp about a foot long, and you would press it on a piece of paper, and that seal would be embossed on the paper, and then you would submit that original document to the bank for the company incorporation, the bank account opening. So a lot of those things were required. So that one requirement thankfully has been removed. It's no longer required, and companies, actually the whole section pertaining to company seal has been done away with, because it's just so archaic and it's no longer utilized as such. What happened in 2017 when the new law was introduced, they required that as soon as you incorporate a company, within 30 days, you are required to deposit the share deposit money into the account of the company. And this used to be a problem for startups and founders typically who do not have the funds. And when you are registering a company, you generally don't think of it as a corporate structure where the shareholders are putting in money, and then there are certain expenditures. A lot of the times startups don't have expenditure as such. They are just working by themselves and working in developing a product. So what the SECP has done is removed the original requirement that was in the law that said that within 30 days you are required to deposit money in the company as soon as it is registered. Within 30 days. That requirement has been removed. But what has I don't think it is going to mean that you will not be required to put any money in the company. Essentially, the regulator, the SECP, will now be able to draft regulations around it, and I feel that they will be in a position to extend certain benefits to the startups. Another expenditure that startups were required to incur as soon as they registered a company was they were required to engage a chartered accountant. That requirement has been removed. So it is not immediately required. It's something that you can do later on. I would never say that you have the financial statements of a company. The founders typically should not be in the habit of making all of the financial statements themselves. They should be taking the advice of some chartered accountants. So with all due respect to the profession of chartered accountants and the work they do, it's important. But the only thing that has changed is perhaps the requirement to engage the chartered accountant immediately has been removed. But obviously, you still need a chartered accountant going forward.
Okay.
One thing that perhaps is going in the opposite direction, but has to be mentioned because I think the audience need to hear this, is that you in the past, if you had a company and you let's say we go back to the example of you and me, we really should think about setting up a startup, Fasieh. If you and I are the only shareholders in the company, and both you and I are the directors, and let's say you are the CEO of the company, now if there is no change in the subsequent year, there was no requirement to file the statutory returns every year. Now that relaxation has been removed. Now, when we do register our startup, we will be required to file the annual statutory returns irrespective of whether there is any change or not. It is not too cumbersome. I mean, a lot of people have suggested that this is somehow a negative thing. I do feel that it's one of those things. If you are a company and if you're doing something, you're filing your tax returns. So filing your statutory returns shouldn't be too much of a hassle. Plus, in the ease of doing business domain, SECP has made it a lot simpler to file statutory returns. You can do it online. It's not very complicated. it's not as user friendly as perhaps it could be. And
Under which area one has to go, sorry to cut you, online to file these returns? Or
on the SECP
is there a
website.
check? Okay. Is there a checklist on SECP's website that startups can go and access that? So hota you have mostly when startups actually join more incubators and accelerators, they are bound to get themselves registered as a legal entity. But before they're part of any such formal organization or activity, they keep working in a very informal structure to bypass or stay away from the regulations for many reasons whatsoever. But when they have to raise investment, when they have to interact with people, when they have to receive payments, they need to get pretty formalized and they need to register. So they shy away from it because often we have thought of it as something which is cumbersome because you have to interact with the government, it's very long, you have to hire middlemen or seek help from lawyers or accountants, as you just mentioned in this case. So while we've jumped a lot of spaces on the ease of doing business recently, and I'm sure the recent reforms will help us further go up, what do you say for those startups? And there is a question here as well, which relates to a little bit to that as well. Well, I don't want to go to the question completely, but which pretty much says that if we remain in an informal way, we're not structured formally, we do not have to comply to a lot of regulations. But when we do not have a way to keep track of them. कि मुझे अब कौन सी return जमा करानी थी, and as you mentioned, so who to go to, and where is this checklist or a Bible that one can access, and which is not a very, very legal way, but also something that a common man can read.
So Fasieh, this is a startup idea right there. Somebody making a checklist for any startup who wants to remain compliant, who wants to know exactly when to file tax returns and statutory returns. But on a more serious note, the SECP has a guideline. I think it's fairly readable. It's available on their website. They have a startup specific portal as well. People can go there. But I do want to take a step back, and I do want to address the elephant in the room. And I feel that a lot of startups actually do not take or make the effort of understanding what their regulatory obligations are. And it's sort of like a ostrich solution where you stick your head in a sand in the hope that nobody is going to come to you and make or create problems for you. I feel the solution to any challenge of this sort is to face it head on. Take the effort of understanding exactly what your regulatory requirements are. FBR is not easy, but at the same time, you as a startup, you need to understand what your tax obligations are. No investor is going to talk to you if you're not tax compliant. आप टैक्स चोरी करते हैं तो आप अपना बिजनेस तो कर लेंगे, अपने बिस्तर के नीचे पैसे तो छुपा लेंगे, बट इन्वेस्टर आपके साथ काम नहीं करेगा. And the same goes with other regulatory compliances. You need to have a compliance culture in order for you to be taken seriously by anyone. That's 2. 3, at the same time, all that I've said, I do not encourage founders to go out and register companies on day one. There are some fundamental issues associated with that. So what a lot of founders, I feel, end up doing is that you and I fell in the same bucket as well, that we gave each other 50% shareholding without talking about exactly what the role and responsibility of the parties are, or why we are giving each other that equity. So understanding what the shareholder or co-founder is bringing to the table, what is the importance of that, and what that equity structure would be, let's say 1 year down the road. And so I feel that the incorporation should be an event that should happen sometime when you are much more crystallized in terms of what your business idea is. You have a solution that is sort of nearing completion, and now you are going to start talking to third parties. That is probably around the time when you start looking at registration of the company. If you incorporate a company on day one, just because you and I and friends and we say, oh, let's go since it only takes 4 hours to register a company on the SECP website now, let's just register a company, but we don't take it anywhere after that because, our equity positions do not reflect the reality, or we are no longer interested in continuing with the startup. So it's sort of, there isn't a perfect time, I can say, but there is definitely not the beginning.
This is a very valuable advice. Thank you. But company registration is not the only form of a business to be legally recognized either, right? This is also a very big pitfall that most of people who do not have any advisors to guide them, unfortunately, go up registering a private limited company upfront, which they do not realize has a lot of obligations and, as you just mentioned, to adhere to. So, and if you're not meticulously compliant about them, you will fall in a lot of issues regarding whether it is the FBR chasing you for not filing returns on time, or whether it is your bank or your investors or partners chasing you that you're not showing up as a compliant corporate entity. So sole proprietorship, single member company, or an association of persons, often called partnership otherwise, there are many legal forms, and I believe our startups or founders who joined us should actually go. There is a lot of material online available on SECP's website and otherwise as well. And those of you who have also asked, of course, at the end, we'll request Barrister Uzair to share his contact details or however you can reach him. So do reach out to people who can give you the advice from a legal standpoint, but much of it is available online. Don't go upfront unless you need to be a private limited company, which is often the reason of raising capitals or issues of shares or otherwise. So let's jump on to questions, Uzair. Lots and lots of questions pouring in from Facebook and online here as well. So I would request if you can give quick, brief answers, and because I would love that we answer all of them if I can in this short time. So this one is from Samir Bukhari. He says, can you please shed some light on LLP registrations with SECP, the steps required and the reporting requirements? Also, can it be done all online?
Yes, it can be done online. If you go to the SCCP website, I believe that they have a step-by-step guide for registration of an LLP.
Can you please tell whether it is secp.gov.pk or startup.scp, the portal they have?
No, secp.gov.pk.
Okay.
And I do want to point out very quickly that LLP is only advisable if you are in the services business, or if you are in the nature where you are unlikely to attract a lot of equity injection, because startups, if you let's say are providing consultancy business, then LLP is a perfect solution for you, and private company perhaps is not that perfect. But so if you go down that road, then perhaps you need to understand and appreciate why you're doing it. Number one. Number two, tax liability and reporting requirements are exactly the same as a private limited company. So it is treated under law as a private limited company by the tax authorities.
Okay, thank you. I've also typed the answer, but I believe it's not difficult for me to type the answers for you. So I hope you guys are listening. Recording will be available. I won't be able to type the answers next. So I'll just ask the questions. The next is from Wajahat Khan. It's a little bit longer one. He says, 7th schedule of the Companies Act 2017 specifically lays down the table of fees to be paid to the registrar and the commission by the companies under section 462 and 469, both in the submission of documents electronically or in the physical form with different fee structure. As electronically filled documents require electronic signatures or advanced electronic signatures, therefore they shall be subject to the authentication under Electronic Transactions Ordinance. I don't know the question, but I believe he's just trying to ask you if that is so.
So no, it is probably not the case. Number one, you can file documents online by printing it, signing it, and submitting it online. So this is what has been happening. You can now utilize Electronic Transaction Ordinance, and Wajahat, for all intents and purposes, I'm extremely happy that there is finally an interest around this. can you believe this law was introduced in 2002, and for 18 years we have not utilized the full benefits of this law? This is such an important document, important piece of law that allows transactions. It essentially recognizes electronic transactions. You and I can enter into a contract in email form without having to print it on a stamp paper and get it signed. All of that is covered under this law. But unfortunately, the remaining government agencies were not utilizing the full benefits of this. Now, for example, a few years back, I think it's about 5-6 years now, maybe less, even the government of Punjab has introduced the e-stamp website where you can obtain the stamp online. What perhaps is the logical future of this is that you just pay the fee online and you get some sort of a digital sticker that you can put on the document, but or a unique reference number that you put on your document, and that should be it. So perhaps we can ultimately get away with even going to the bank and obtaining the computerized stamp paper. But I am quite happy that we are finally looking at electronic transaction ordinance.
Excellent. I believe Wajahat had another question on the same line, so I believe that's answered. This is from Shabaz Ali Khan. Can a company or a startup use a convertible note for raising investment in Pakistan as per the Pakistani law? Was convertible note part of the discussion in the terms of the new amendment? Well, I do know that Shabaz, before Barrister Uzair answers, it was part of a discussion. We were there, but let him answer of it being a part of the law.
So the short answer to that is yes, convertible note is permitted. In fact, the Securities Act specifically calls convertible note as a type of security. So to the short answer to that is yes, you can certainly raise investments by issuing a convertible note. Perhaps what is still not perfectly available is that you can incorporate that convertible note in terms of your statutory filings that you do before the SECP. So that is something that is perhaps a gap, but the short answer is yes, you can raise investments. It is recognized under law. A lot of investments that are happening right now are in the form of convertible notes, and both local and foreign. So a lot of international investors,
that's interesting,
who are undertaking angel investments, where especially it's not a priced round and you do not exactly know what the value of the startup would be. Convertible note becomes a much more easier document to execute. So it's something that's happening, and it's recognized, absolutely. And it's a contract. You see, the company is giving a promise that sometime in the future it is going to convert this amount of money into equity. So it's a contract, and there is nothing in the law to prevent that.
Thank you. The next one is from Farooq Kandhari. He says, under the new definition, can a startup company be a non-tech company such as a sports management company or an event management company, for the sake of understanding? It's a good question, although it may be a very simple question for many, but yeah, so is the definition of a startup limited to technology?
No, it is not in the grand scheme of things, but there are certain not all companies are startups. Let me put it this way. And there are certain things that you need to be doing in terms of what you do. So as I said in the beginning, the definition, let me just open it up so that I can give specific reference to it.
Guys, keep your questions, please, short.
Yeah,
those questions that have been asked, don't re-ask them. Thank you.
So Fasieh, it's basically if you are working towards innovation, development, or improvement of products, so the goods are definitely included, or processes or services, or is a scalable business model with a high potential of employment generation or wealth generation, or for such other purposes as may be specified. So in the grand scheme of things, I would say a lot is covered in this. A simple brick and mortar shop is unlikely to be covered. But if you are innovative and you are disrupting your industry, then of course you'll be quite likely to be classified as a startup.
Brilliant, thank you. We'll also take some questions from Facebook that we have received. Hassan Zamir, you have raised your hand. If you have a query, please send it in the question and answer section or in the chat section. Thank you. Ji, so this is from Manzoor Aziz. He says, can you please share step-by-step process for documentation preparation for a startup company registration? Mostly aspirants and students have a difficulty in understanding and preparing the required documents. If it is possible, then please do arrange a separate session on this with complete tax and all other requirements under FATF reporting guidelines as well.
Well, so you see, this is a startup idea, Fasieh, I'm telling you.
Lekin baat ye bhi hai ki, I would say this, for a long time, I must confess, I used to hire help from professionals to file my tax returns.
Yeah.
Okay. Yeah. And 6 years or 5 years ago, it dawned upon me that I've been working in enabling people on technology for such a long time. What could be so difficult? And I was working in government, right? E-governance and all.
Yeah.
And I went through the income tax ordinance on my own, section by section. What does this mean? Although it is absolutely not user-friendly, but I started filing my own return. Although it still scares me when I know that the time is near and I have to file because it's a huge ordeal to go through it. But the same happened when I was about to register my company, my own startup. And I thought it would take time, but then we're also working with startups here as well. This has gone significantly down. It is all online. It is, all the details are there. So Manzoor, if you're listening, I would request Uzair to add more if he wants to, but this is all online. It takes less than a day to process. In terms of document or some basic steps, perhaps Uzair, you could share some.
No, I don't think that I can add anything else to it. I think it's just an attitude. So you have to take out the effort. You're already on the internet. Go and Google the documents that are required. If you search the SECP's website in particular, you'll find they have the guide that is there. And the process is not difficult at all. You can do it online. If you do face any issues, you can ask around, but generally it's a very straightforward process. It's not perfect, of course, but you don't need, hands down, you don't need a lawyer to help you register a company in Pakistan.
All right. The next question is from Uruj Kamal again from Facebook. It is a little bit to some extent you've already answered to this, but let's have a short one. So with respect to informal entrepreneurs, how does regulatory framework aim to cater them? New startups actually prefer remaining informal to avoid regulations. And is it wise to go for any legalities at early stage? I believe she's trying to say to be a formal registered entity at an early stage. Yeah.
So as I said, it's not, there isn't a perfect time. The beginning is definitely not perfect, but it is probably a stage where you are quite clear where you are in terms of your business, and you feel that you want to now start talking to third parties in terms of providing your products and services. You want to potentially start attracting investments. So once you are nearing that stage, then perhaps you can then undertake the formal incorporation and structure. Firstly, I do want to give one particular comment that I've often heard from investors, and that is that they do not like to talk to any startup that is not well versed in the regulatory regime that they are operating in. Now, what does that mean? That means that if you are, let's say, manufacturing a particular product, you need to understand the exact licenses that are required to manufacture that product. And if you are not aware of those licensing requirements, they are going to think of you as somebody who's not very serious. Now, I'm not saying that there will be absolute shutting of the door as far as the investor is concerned if you are slightly non-compliant, right? So a lot of times startups are operating on the fringes and they want to challenge what is the norm, and equity crowdfunding is perhaps a very good example of that, that it is just around the edges and there is a slight gray area that you want to operate in, and you as the startup understand that this is what you are doing, and whoever investor that you're talking to, you explain that you understand that this is a gray area, the rest of it I'm perfectly clear. But if you say that I don't know how to file my taxes, or sorry, if you say that I haven't filed my taxes in the last 2 years, they are not going to treat you very seriously.
I absolutely agree. And I hope all of those who are listening, you don't take it lightly, you can shy away from it. If you're talking in terms of any formal arrangement, partnership, investment, or anything of that sort, you must know the space you're operating in. The last thing you should know, you would like to do is that you slap with a notice on your on your desk or in your email that you are, non-compliant, etc. So that's not what we would like to go for. Quickly, Ji, Farhan Azim Siddiqui says, can you please comment regarding different types of businesses that can be registered with SECP? Is it only for registering a private company or for partnership, or what other sorts?
So there are two. One is a limited liability partnership that was recently introduced, and the second is the company, private limited company. If you are a sole proprietor business, it is not registered with the SECP. It is just registered with the FBR, and you tell the FBR that I've set up this sole proprietor business.
The next question is from Hassan Zamir. If we already registered our startup as a private limited company before this amendment came into play, so are we also considered as a startup, or what advantages, disadvantages we can have from this act? Do we need to go and update our records?
That's a very good question. So number one, yes. It basically, you benefit from it if you were incorporated any time in the last 10 years. So if you were incorporated, let's say in 2018, you're covered. If you were incorporated in 2011, you're still a startup. But if you are incorporated in 2009, then you're not a startup because you've been in business for more than 10 years. Number one. Number two, as far as the benefits, I would say that a lot of the benefits have not been fully unlocked. The law merely recognizes startups as a special entity that has to be given certain privileges and protections. And those privileges and protections are going to come towards the startups in the near future. So for example, there may be relaxation in filing requirements. There may be relaxation in terms of the capital contribution that we have talked about. So a lot of relaxations and facilitations are going to be made available to startups in the future, which are perhaps not available right now.
All right. Another question is by Wajahat, that NIFT, which is aggregated under basically the Electronic Certification and Accreditation Council, was providing digital signature services for SECP e-services up till 2017 for 9 years. 70,000 businesses were using it, and then all of a sudden those services have been halted by SECP for the past few years. While we all are working in a very digital age right now, so the importance of digital identity is so clear to everyone. Your views on that?
So DIFT is one entity that is providing accredited signature services. It is by no means the only one. Now, if I believe that there is at least one other startup that is actually providing digital signature services in Pakistan, and there is definitely an opportunity for others as well. So SECP had the option of utilizing NIFT. For whatever reason, I think we should let SECP answer that, yeah, why they removed or stopped using NIFT, but they no longer use it. So
NIFT was just one of the agencies that there must be.
Yeah, of course. So it's not inclusive.
So let's move on.
Yeah.
Brilliant. This is by a case example by Muhammad Ali Jamal. So he says that for employee stock option, if a startup hires a person and gives them a stock option, let's say 2%, of their stay in the startup for 2 years, but the startup during this time also receives an investment and share positions gets diluted. Will that also dilute, or would the same person who was given 2% according to the law would it be subject to dilution or not, basically?
Of course, the answer is yes. Essentially, if you we'll go back to the example that we were discussing, right? So you and I have 100 shares, and we decide to give 10 shares to another shareholder. Now, what is the total number of shares? 110. If we issue 90 more shares, you are being diluted. I myself, I'm being diluted, and the employee stock option, the person that we gave that person shares, the 10 shares, he's going to be diluted as a matter of percentage. The answer is yes, of course. Everybody will be diluted.
Okay. So the next one is, isn't equity crowdfunding prohibited under the ambit of Section 84 of Companies Act, which prohibits acceptance of deposits from the public?
That's a very good question. So this is being discussed, or this was discussed quite extensively when we were working towards drafting the equity crowdfunding regulations. Now, what is relevant is the definition of deposit and the mode of attracting that deposit. And it was felt that if you publish it in the newspaper, for example, or you put it out on the television, that you are attracting these deposits, then it would be illegal. And the argument that we built was that it would not be illegal if we create a moat around it, and essentially it's there is a gatekeeper there, and you have a website where you log in, you are an accredited investor, there is a criteria for that, and you meet that. If you have access to that information, then it is not public. So you're not going to the public.
Okay. What are the conditions? So this is a question by Shamaila. She's asking, what are the conditions for registering non-profit organization? By the way, I do know this is not happening these days. We have been trying to get one as well. It's not that easy to do it. But let the professional person answer. And is it better to register as a consultancy firm as compared to a non-profit? So
I know exactly what Shumaila is talking about. So you are spot on. Incorporating a non-profit is not easy. This happened, I think, about 4 or 5 years ago, when there was a lot of issues around the misuse of the investment, the donations that were being given to the non-profit organizations. It's not impossible, right? So there is a process, and that process can range anywhere between 4 to 6 months. And currently, your application goes to the special branch of the police. Last year we incorporated a non-profit for a large organization, and it took 3 months. But the special branch then sends it to 4 security agencies. I believe it's the FIA, the CIA, not the American one, Pakistani, I think it's Intelligence Bureau and one other. So all of the 4 and MI, and all of those 4 security agencies approve the members who are part of the non-profit organization, and then once it is done, you are registered. So definitely, if you are in a consultancy business, then perhaps it is more easier for you to just register yourself as a consultancy company.
This is a question by Bilal. He says, it's a layman question perhaps, but if you're starting a sole proprietorship firm and we register it with BEC, which I believe is the equivalent to SECP in the Punjab province.
No. So this is Pakistan Engineering Council.
Pakistan Engineering Council, okay, sorry. Register it with BEC, which already requires an NTN number from the RTO. Do we still need to get registered with SECP? If yes, why?
No.
For sole proprietorship, you said it's not.
Yeah, you're not required.
Yeah. You're not.
Yeah.
He already explained for the company. So, yeah, Omar Farooq says, can we presently raise equity crowdfunding abroad, let's say from UK, and bring that money in Pakistan, or invest internationally on product development and marketing, but the company is registered in Pakistan?
Oh, Umar has opened such a huge can of worms. I don't think we can answer it today. But you need to, I'll give you the brief reference to the laws that you can perhaps look at yourself. You need to look at Chapter 19 of the Foreign Exchange Manual. You need to look at Chapter 20 of the Foreign Exchange Manual. You need to look at Section 13 of the Foreign Exchange Regulation Act 1947. And then we can have this conversation. The short answer is it's not easy, but perhaps you can do it.
Brilliant. Thank you so much, Uzair. This is the last question from Sundas. She says, can we put our own policies and customize it to describe the policies after registering a company? I believe policies are not required. It's memorandum and articles.
Yes, I think what Sundas is perhaps referring to is indeed the articles. And yes, you can amend the articles based on your own interests and desires, and you can structure. So perhaps we can spend half a minute on this. So essentially, there are two constituting documents when you register a company. One is the memorandum, and the second is the articles. The memorandum tells the public what this company does. For example, it says that this is a company that is in the business of manufacturing certain goods. So that is the public facing document. The articles are essentially the constitution of the company and how it operates. For example, how the shareholder meeting is going to be called, how the director meetings is going to be called. Unless you violate the company's law and you go anywhere outside of the purview of what is permitted under the company law, you can change the articles and you can do what you want.
Thank you. Yeah, so there's lots of questions pouring in. Guys, that's enough. I wish I could answer. But this is the last. As Mr. Uzair is saying, many changes will be unlocked in future since the law has been enforced. So basically what Ibrar has asked is that if the law has been enforced and it's been introduced, why we cannot enjoy the features or the changes that have been reflected there against? Why would it be unlocked in the future?
So if you look at the documents, look at the changes that have been made, they essentially say that the SECP is going to make regulations for that. So essentially what the SECP is going to do is it is going to pass regulations, and those regulations are going to determine how or what is the process, what are the documentation that you will be required. So the law essentially unlocks and makes it possible for the SECP to ultimately make it possible for startups to do what they want to do.
Brilliant. Thank you so much. This brings this discussion to a close. We've actually taken more time from you, Uzair, and also audience who has been very consistently available, live, interacting with us. Thank you so much, guys. Those who are online on Zoom, those who joined us from Facebook, I really appreciate. Someone raised their hand, Wasim. If you have any question, please share it. A second. Yeah. Yes, Bilal, AOP is different from a sole proprietor. AOP is basically essentially a partnership. Okay, so many people are raising hands, Asad and Shamaila and others. I wish I could allow everyone to talk, but if you have questions, you have already placed them, we've answered. Shamaila, your question has already been answered by Uzair.
So I'm just gonna lay it out there. I've put my email address in the chat. And if there are follow-up questions, I'll be more than happy to answer them. And
I was about to say the same. How can they contact you? So I believe you're reachable on LinkedIn as well.
I'm reachable on LinkedIn. Yes.
Yes. So guys, you can look him up, connect with him on Ahmed Uzair. He goes by that name on LinkedIn. Shamaila, Wasim, and Asad, I see your hands up. We are unfortunately close with 23 minutes beyond the time that we scheduled. If Uzair allows, I could have asked you, but even if he allows, he has also other commitments and his family to give time to. He's shared his email address. It's UZAIR, which is Uzair @auclaw.com. So yeah, you could reach out to him with your queries. Thank you so much. This session was brought to you in partnership with our partners, ACCA Global. We also have Ali Shan Haq here from ACCA. So thank you, Ali. Thank you, ACCA. I hope the members from ACCA community also enjoyed this conversation. It was very informative for me and very insightful. Thank you, Uzair. I believe we need to do more on probably a legal clinic, perhaps, for our startups, because there's a lot of interest now on IP, on filing patents, on copyright infringements, and on trademarks, which is very, very important. Let's have a chat sometime later on that. So thank you so much for your time. Take care. Have a good night.
My
thank you,
pleasure.
ladies and gentlemen.
My pleasure. My pleasure. Thank you, Fasieh. Thank you. Take care, everybody. Bye-bye.
Bye. Thank you.